Hello everyone, good evening. My name is Satyajit and I welcome you all on this platform of Dnyanadeep Academy, where we are going to discuss a few questions from UPSC 2023, that is called as CSP, Civil Services Prelims Examination. And the subject today is of Indian polity. As you know, since last 1 month, we have been running this series underscoring the importance of the previous year's question papers in preparation of your prelims examination and the strength and the command that you need on these questions. That's how we have started this series, where we are going to help you to diagnose, to identify the important areas where the UPSC is focusing on. And we have divided various subjects among our team. And now I'm going to discuss Indian polity today, where we have identified 15 such questions from CSP 23. The first question I would like to discuss is about very important, very doubtful question maybe. In essence, what does due process of law mean? If you identify the question, this idea is from Article 21, the due process of law. There has been a continuous debate about the constitution, where our constitution does it prefer due process of law or process established by the law. And that debate have already concluded in Maneka Gandhi case. But if you're a student of political science, and if you've studied political science in depth, you might be knowing about Aristotle's concept of due process of law, okay, or Aristotle's emphasis on the reasonableness, fairness of a law. What do you mean by this concept of due process of law? Actually, this concept is about applying a fair principles, applying the just principles while formulating the law, at the same time implementing the law. But before that, let's first read the options, because this question was about the options and the complexity of options that they have designed. The first, the principles of natural justice. The second option was about the procedure established by the law. The third was about fair application of the law. And the fourth was equality before law. By going in simple way, you can identify the four options are nearly similar, but we can identify the most or not most probable options first. We will eliminate the first few options which are not actually in the line with the question. Of course, the due process of law is not just about equality before law. Okay, it can be a fair application of law. It can be the procedure established by the law, but actually I have just already mentioned the due process of law versus process established by the law. That's how this due process of law is far different than the process established by the law. Okay. What do we mean by this procedure established by the law? The courts will take a review of the laws, that is called a judicial review, and they will only review if the law is in the lines with the process established by the constitution. And in due process, they will identify everything about the law, its fairness, is it arbitrary, is it not arbitrary, or something like this. So these two options are fair enough. I mean, they are absolutely wrong, right? But the question was about these two options. The confusion was about these two options. The first is the principle of natural justice, and second is fair principle of law. But before we delve into the question, the analysis, I would like to mention few thinkers, few ideas. The first thinker is about Aristotle, right? Aristotle. And the second is John Locke. Even I would like to mention few evidences from Magna Carta. I would like to also mention the evidence of the freedom struggle of America. And in all these freedom struggles, or this Magna Carta, the book, or the idea of Aristotle and John Locke, they have focused on nothing but the reasonableness. The law should be reasonable enough. Okay, it should be, yes, of course, it should be established by the law, but the reasonableness should be established by the fair application of law also. Reasonableness plus just and fair, right? And all these principles, the three principles, reasonableness, just law, and fairness of the law, have been established in the famous Meneka Gandhi case in India. Okay, Meneka Gandhi case in India, where Supreme Court suggested that any law that is going to be implemented or that is going to be enacted, both enacted as well as implemented, the processes should be based on the principles, the three principles called as the fairness, the reasonableness, and the justness. Okay. By giving these evidences, in my opinion, because this question is still doubtful, which answer is exactly right is still doubtful. And unfortunately, UPSC declares his answer key 1 year after the conduct of the examination and just after the result of that particular year. So we were actually predicting that the answer sheet, I mean answer key, the official answer key will come just before the actual actual result of this examination. But let's predict the answer. In my sense, will be the principle of natural justice. Okay. And if you refer to this principle of natural justice, it actually talks about these three principles: the principle of fairness, the principle of reasonableness, and the principle of justness of any law. That means the law should follow the justness not only in its letters but also in its spirit. That's why the A option can be most probably this is going to be the right answer. What about the second question? The second question is about two statements. This question is from the prisons, and again the ongoing debate since last 75 years is about the prison reforms. And today only we have very important news today from the prisons of Uttar Pradesh. You know, Mukhtar Ansari has been died or killed, whatever that debate is. But Mukhtar Ansari is again the idea is about prisons. Statement 1 is about in India, the prisons are managed by the state governments with their own rules, okay, and regulations for the day-to-day administration of the prisons. What do you think? This idea, this statement 1, is it wrong or right? And if you observe the state list and exactly the entry 4 in the state list, okay, we have the in 7th schedule 3 list. So state list entry 4 talks about this idea. State list entry 4. Okay, yes, exactly. The prisons is a state topic. Okay, and secondly, in India, the prisons are governed by the Prisons Act 1894, which expressly kept the subject of the prisons in the control of provincial governments. Okay, yes, exactly. This statement is also right. The Prisons Act 1894 deals with the prisons topic, and it is a provincial subject, right? Both the statements are correct, but none of them justifies, none of them actually supports one another, because these two important facts are separate facts, separate truths. Okay, they have no direct link as per se as given in the options, because the options are in this way. First option is both statement are correct, and statement 2 is the correct explanation of statement 1. Okay, yes, both statements are correct, but the statement 2 is not the correct explanation of 1, as they are two separate facts. Okay, so B option will be right, and these are not that much logical options. What about the third question? Which one of the following statement best reflects the chief purpose of the constitution of country? Why do any country enact constitution? Okay, and the idea of constitution goes into the idea of constitutionalism. Again, Aristotle is the father of idea of constitutionalism, and according to Aristotle, what do you mean by constitutionalism? Constitutionalism is nothing but principle which limits the powers of the government, right? And the powers, I mean the freedoms and the rights of the citizens, the people, are upheld by the constitutionalism. And that's how very simple question this was. It determines the objective of making necessary laws. Fine. It enables the creation of political offices and governance. Okay, this is also fine. It defines the limits of the powers of the government, and the fourth, what it secures the social justice, social equality, and social security. Actually, if you observe the options, you will observe reasonable similarity among them, and you might get confused, because all of these options, they look correct. Okay, but among these 4 options, you have to choose the most correct. Okay, the most suitable, most appropriate among them. And that's how, if I mark in number of stars or in number of, let's say, tick marks, the first option I will give only 1 star out of 5. Okay, the second, it enables the creation of political officers. Okay, 2 star out of 5. It goes like it secures social justice, 3 star above 5. And this is about 5 out of 5. Okay, so this is the most probable answer of any constitution, because the idea of constitutionalism talks about this. Idea of constitutionalism by Aristotle. Okay, so it limits and it defines the powers of any government. Now, question 4 is about, in India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of the fundamental right, and the options were the First Amendment, 42nd Amendment, 44th, 86th Amendment. This question was somewhat, let's say, of the medium range, somewhat difficult. Okay, not that much difficult, but somewhat difficult, of medium range, not easy. But if you are thorough about the idea of fundamental rights and their amendability, okay, are fundamental rights amendable? I mean, can Parliament amend the fundamental rights, है ना? And can judiciary, I mean, can judiciary interpret? Can judiciary interfere in that amending power of the Parliament? This debate started actually just we enacted our constitution in 1950s. And the first case which came along with this amendability of the fundamental right was Champakam Dorai Ranjan case. You know about that case, I know, but you have to just revise that idea. The Champakam Dorai Ranjan case, in which Supreme Court upheld that key fundamental rights are not amendable. Okay, that means you cannot amend the fundamental rights just with a simple ordinary law. If you want to change the fundamental rights, you have to go for a proper constitutional amendment. Only constitutional amendment of the proper sense can change the fundamental right, and Parliament can interfere into the fundamental rights. Okay, so Supreme Court reiterated that the amending power of the Parliament is there for the fundamental right, but with a proper amending procedure of the Parliament. Okay, and that's how once the after this Champakam Dorai Ranjan case, Supreme Court gave this judgment. The Parliament went for the first constitutional amendment. And in this first constitutional amendment, Parliament changed two important, you can say, articles, or it added two important articles in Constitution. That is Article 31B and Article 31A. Okay, so the first amendment, Constitutional Amendment Act, after Champakam Dorai Ranjan case, right? Champakam Dorai Ranjan case, first constitutional amendment, it changed Article 31A, Article 31B. Article 31A secured few important laws, few important provisions in the Constitution and legislations from amending power of the Parliament. I mean, from judicial review. I mean, I can say from judicial review, judicial interpretation, they saved those articles, so saved those laws. And Article 31B added a 9th schedule in the Constitution, again in which Supreme Court cannot take, or judiciary cannot take a review. That's how the fundamental rights were again shadowed from the oversight of the judiciary, judicial interpretation, and therefore the question for this question, the option 1 was right. The First Amendment is the right answer. And subsequently, 42nd Constitutional Amendment Act also talks about amendability of fundamental right, but this question talks about the overcome the judicial interpretation of the fundamental right. So kuni start killer, so started with the First Amendment, and now and that's how it started with First Amendment and went on 42, 44th and etc. Now what about the the fifth question? Consider the following organizations as bodies in the Constitution, and they have given four bodies, different bodies, in which they are asking about how many of them are constitutional bodies actually. As you know, in India we have different bodies. They source from constitution, either from legislation, or either from executive orders. So not all bodies are legislative or statutory, not all bodies are constitutional, and not all bodies are derived from the executive orders. But if you mention these four different bodies, let's talk about their sources. The first, National Commission for Backward Classes, it is of course a constitutional body, and this constitutional body earlier, by the way, it was earlier a statutory body. It had source from legislation, but in 2018, 102nd Constitutional Amendment Act of 2018 changed its nature from statutory to constitutional body, and it added one article, this amendment article 338B, and that's how under article 338B, this body, National Commission for Backward Classes, is now a constitutional body. The National Human Rights Commission is again a statutory body, the Human Rights Act, right, 1993. The National Law Commission is again a statutory body, and the National Consumer Dispute Redressal Commission is also a body derived from a law, not from the Constitution. So these three bodies are statutory, and the Commission for Backward Classes is constitutional. So let's read about the question again. How many of them are constitutional? So the answer will be only one. Okay, only one among them is constitutional bodies. Sixth, if the election of President of India is declared void by the Supreme Court, right? And this question, unfortunately, look at that, how UPSC designs questions from prelims, for prelims and also for mains, and that is sourced from current affairs, because this year, I mean the last year, India witnessed presidential elections, right? And Draupadi Murmu was elected as the President of India. And it was very predictable that UPSC is going to ask about the election procedure or election processes of the President of India. And logically, out of 15 questions of Indian polity in 2023, 2 questions were directly asked from the process of election of the President of India. Okay. If election of the President of India is declared void by the Supreme Court of India, all the acts done by him or her in the performance of the duties of his or her office of the President before the date of the decision, right, are or become invalid. If you observe, this statement is again logically is very wrong statement, because the logic is there as president is just a celebrity, or you can say just a formal office, right, a celebrity office, but the actual powers are with the prime minister. So there is no need to actually make invalid the laws or the actions taken by the president in his or her office before getting invalid or before getting impeached out of the office. So that's why the first statement becomes wrong. And there is another logic from the Western sense in my head that is going on is there is one notion called as the king can do no wrong. Okay, the king can do no wrong. That's how the president, whatever his actions are there, they are still valid even after his or her office, or even after his or her impeachment, or the election process is declared invalid. So the first option is wrong. Okay. Elections for the post of President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to be taken place. Again, there is one important provision in our constitution regarding president, that the vacancies in the electoral college of the president, if there is any vacancy in electoral college, this cannot be the ground for making the presidential office or the presidential election invalid. So basically, whatever the vacancy is there in the electoral office, still the elections are to be declared valid. Again, there is one important provision in our constitution that before the expiry of the tenure of a president, the process for the next president should be completed before that process, right? So that's how there shall be a president. Okay. So the second statement is again wrong. When a bill is presented to the President of India, the constitution prescribes the time limit within which he or she declares his assent. Okay. So basically, right, constitution prescribes the time limit? No, the constitution does not prescribe the time limit. And that's how you can say, you can observe here, when a bill is presented to the President of India, the procedure, constitution prescribes the time limit. No, this is wrong. So basically, the election for the post of President of can be postponed. No, it cannot be postponed. This is again wrong. And if the election of the President of India is declared void by the Supreme Court of India, all the acts done by him or her preference are become invalid. This is also wrong. So all these three statements were wrong. Let's go for the next statement. The none was answer. I mean, how many are correct? None. Okay. Seventh, with reference to the finance bill and the money bill in Indian Constitution, in Indian Parliament, consider the following statements. They have again given three statements, and again the trend you have to observe that what they're doing in UPSC prelims examination since last 3-4 years. Yes, there are 100 questions, but each option, as they are increasing the number of options in a particular question, the number of questions, the processing that we need to do in our brains, the knowledge we require to solve this question becomes threefold or fourfold. So actually the questions are 100, but the number of questions, number of decisions that we have to take becomes somewhere like 300 decisions for 100 questions. Again, the three statements, you have to just find out which is the correct statement. The three different questions are becoming here. So trend is that be prepared for lengthy questions, be prepared for the multiple options questions. And that's how, again, when the Lok Sabha transmits the finance bill to the Rajya Sabha, it can amend or reject the bill. Before going into the details of this question, you have to be thorough with the idea of money bill and finance bill. As you know, in Indian Constitution, we have two important articles dealing with money bill, that is 110 and 119. 110 talks about the what do we mean by money bill, and 109 talks about how to pass that bill. So this is very surprising fact कि 109 talks about the procedure to pass the bill, and 110 talks about the money bill. What do you mean by money bill? And there is third important article in our constitution that is called as Article 117, which deals with the provisions of the finance bill. You have to be thorough with 109, 110 and 117 to solve this answer. You have to be thorough with what do you mean by money bill and what do you mean by finance bill. You have to be thorough what is finance bill type 1, what is finance bill type 2, and then only you can solve the this question. But the basic idea or the basic difference between these two bills, types of bills, is money bill and finance bill. Money bill gives Lok Sabha more power than Rajya Sabha, and in context of finance bill is just like ordinary bill, but it is suggested, it is recommended by the president to put forth in the Lok Sabha and Rajya Sabha. So presidential assent, presidential recommendation is required to put forth the finance bill first. Okay, so the first change is there. Otherwise it is just an ordinary bill. And second important idea about finance bill is that finance bill is firstly put in Lok Sabha. Okay, and once the Lok Sabha passes the finance bill, it becomes just like an ordinary bill, and dealing with Rajya Sabha, the finance bill dealing with Rajya Sabha just like ordinary bill. By this knowledge we can solve this question. When the Lok Sabha transmits the finance bill to Rajya Sabha, it can amend or reject the bill. Okay, the question is about finance bill. Yes, Rajya Sabha, it can amend or reject bill. Fine, because when finance bill passes to Rajya Sabha, after passing in Lok Sabha, it is treated as just as an ordinary bill. So option 1 is correct. When Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill. It can only suggest recommendations. Again, this is correct statement, because money bill जेव्हा राज्यसभेत जाईल तेव्हा reject करू शकत नाही or something, it can only amend. And it, in case of disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. Again, the first half of the statement is correct कि joint sitting की provision money bill साठी नाही, but finance bill साठी necessary पण नाही है. Okay, so third statement, if I'm not wrong, third statement is wrong. So by this logic of the knowledge, you can go for eliminating the options. Okay, the first half is here correct, but second is wrong. Therefore, the third statement becomes wrong, right? And this second is correct and first is also correct. So by this knowledge, we can solve this question. Question 7. Yes, only two statements are correct. Statement 1 and statement 2 are correct. Third was wrong. What about the 8th question? Scheduled areas, and scheduled area is again is very important area day by day into the news. The 5th and 6th schedule, you should be thorough about them. And recently Ladakh is observing some protest about the 6th schedule. Okay, so we are predicting that in 2024 prelims they will ask about the 6th schedule. But let's talk about the scheduled areas. This scheduled areas provision is from the Constitution, the 5th schedule or Article 244. Article 244 or the 5th schedule talks about scheduled areas and scheduled tribes. And Article 244 particularly talks about the administrative mechanism, how the scheduled areas are to be administered. This provision is given in Article 244. By that logic, the state governments and the governors become more powerful while dealing with the tribal areas and the scheduled areas. Okay, so within the state, the notification of an area as a scheduled area takes place through the order of president. Perfect. The president declares any area as a scheduled area in a particular state. What is the idea behind scheduled area? Where the population of tribal is more, the area is declared as scheduled area. And who actually orders that or who puts that notification forth is nothing but president. Okay. Secondly, the largest administrative unit forming the scheduled area is district. And second, the lowest is the cluster of villages. Okay. Factually, this statement is also right. Okay, according to 5th schedule and Article 244. 5th schedule and Article 244. Okay, both statements are correct. Third, the chief minister of the concerned states are required to submit annual reports to the Home Ministry on the administration of scheduled areas in the states. Okay, just one word here and there, you are just losing the marks. Okay, but it is not the chief minister, it is the governor. Okay, the governor of that particular state is required to submit the reports about the governing state, or the situation, or the processes that are being held in the scheduled areas. The governor is to submit the report about the procedures and whatever that situation is there in the scheduled areas, the not the chief minister. And that's how this option becomes wrong, this statement becomes wrong. So according to this, only two are correct. Okay, only two statements become right. The ninth, the Supreme Court of India has held in some judgments that the reservation policies that are made under Article 16(4) of the Constitution of India would be limited by Article 335 for the maintenance of efficiency of any of the administration. You know that the government of India is a welfare state, and we provide a reservation or the positive discrimination for certain sections of population which have observed historical discrimination and which are socially and educationally backward. And according to the social and educational backwardness of the particular communities, we provide reservation to scheduled caste, scheduled tribes, OBCs, women, and etc. And that's how. And after the providing that reservation, it should not also impact the merit, it should not also impact the efficiency of the governance, and this statement is correct. And according to, you can observe the Indira Savni case and many other cases, Nagarajan case, Indira Savni case, they have times again and many times Supreme Court has repeated the same statement that the efficiency of the government should not be compromised. So yes, the statement 1 is correct according to Indira Savni case and Nagarajan case. Okay, and statement 2, Article 335 of the Constitution of India defines the term efficiency of the administration or efficiency of the governance. There are many words in our constitution, surprisingly, which have not been defined in our constitution. The words like socialism, the words like fraternity, and many other words. Just like that, the word efficiency of administration has been mentioned in our constitution, but it has not been defined. Okay, so yes, Article 335 of the constitution defines. No, it does not define, it only mentions. Okay, so defines, this becomes wrong and this is right. Okay, so accordingly, statement 1 is correct and statement 2 is wrong. Therefore, our correct option becomes C. Statement 1 is correct and statement 2 is wrong. What about the question 10? With reference to home guards, consider the following statement. Again, this was somewhat out of the box, or out of, let's say, the ritual, or out of the regular questions that have been asked in the UPSC. But you should be prepared about home guards. If you have read about the India Yearbook and something, you might have gone across home guards. What is home guard, by the way? Home guards are nothing but a separate police force which assists the regular police force. They are auxiliary police forces. They help the police system. Okay. So home guards are raised under the Home Guards Act and rules of the central government. But very important provision, you should know that, as I am mentioning here, they are assisting, they are auxiliary to the police force of a particular state. The police force is state topic, is a state subject. Therefore, these home guards cannot be ruled by the central government. Very logical question. म्हणून मला सांगायचं असं आहे की you should use your logic. Okay, even if you are not thorough about what is home guard, or right, but you should be thorough about what is police, and police is, or policing is nothing but a state topic. So how can central government interfere in home guards, right? So basically this is wrong. Okay, the role of home guards is to serve as an auxiliary force to the police, to the maintenance of internal security. Perfect, this is the exact idea of home guards. Second, and the third question, third statement is about to prevent the infiltration on the international borders and coastal areas. The border wing home guards battalion have been raised in some states. Exactly, the border wing of the home guards has been raised in some states like Punjab, and which have some border areas with very complex countries, complex disputes like China, and even what you can say Pakistan. So yes, Punjab is that example. So I can say the third is also right, and that's how from this logic only statement 1 is correct. Okay, I'm really sorry. So correct is about, yeah, 2 correct. Okay, so yeah, this one and this one are correct. I'm just really sorry. Okay, what we talked about, central government is wrong. This is correct and this is also correct. So in question 10, statement 2 and 3 are correct. That's why our answer becomes what? Our answer becomes B. Only 2 statements are correct. Now what about question number 11? Question number 11 was very surprising question, because this question was dealing about the details of particular laws. And from important lesson from this question is that henceforth we have to prepare some laws in details also. The laws, especially, they have mentioned the Official Secrets Act, Indian Evidence Act, right? And thirdly, the Arms Act. And they have asked to join the pairs or are these provisions in the particular act. Okay, so basically we'll read first the action and the act under which it is covered. Action: unauthorized wearing of police or military uniforms. ही जी प्रोव्हिजन आहे ही कुठल्या ऍक्ट मध्ये आहे? द ऑफिशियल सिक्रेट्स ऍक्ट 1923. Okay, again look at that very if you know, then only you can answer this question. So by the knowledge, by the content knowledge, yes, this is the right provision. If you are wearing unauthorized wearing of police and army force, you can be prosecuted under the Official Secrets Act. Secondly, knowingly misleading or otherwise interfering with the police officer or military officer, है ना, when engaged in their duties. Okay, this provision is again, it is given in Official Secrets Act, not in even Indian Evidence Act. Okay, surprising. I mean, this is hardest question of the polity, toughest. Okay, the most tough question of the Indian polity was this, because if you know, then only you can answer. So the right provision should be here. Again, this provision is Indian Official Secrets Act, official OS त्याला आपण म्हणतो. Then the third was about the celebratory gunfire which can endanger the what you can say, the personal safety of the others. This provision is again covered under the Arms Amendment Act 2019. So this was right. So basically in these pairs, only second pair was wrong. And how many pairs are correctly matched? Then the 2 pairs are correctly matched. That's why only 2 is the right answer. Okay, let's talk about this 12. Again, very important question, current affair based question, because the question is about flag, Indian flag, and recently government of India has launched the Har Ghar Tiranga, you know, that policy. So it was very predicted question ki the UPSC might ask about flag. Okay, so consider the following statements in respect of the national flag of India according to the Flag Code of India 2002. One important message from this question is that you should not be thorough about, or you should be thorough about the policy that is in current affairs, but you should also be thorough about the basics of that policy, the basics of that current affairs. Okay, and they are directly asking from the 2002 Flag Code. Okay, let's read about the statements. One of the standard sizes, the national flag of India, is of 600 mm by 400 mm. Particularly the first statement talks about the size, and the standard size they are asking is nothing but 600 by 400 mm. But throughout India, we observe the sizes of our Indian flag in official residences, official you can say cabins of different sizes. Even in the Delhi or even in particular locations of the Pune or etc., the sizes of the flag are so much bigger. Okay, in Delhi NCR, even that cannot place, and even in our Pune, Shaniwar Wada, तुम्ही बघाल तर जागा ती size केवढी आहे flag ची. It's not only 600 by 400 mm. So surprisingly, Indian Flag Code 2002 does not talk about the size, but it talks about the ratio. The ratio should be 3:2, not the size. Okay, and statement 2, the ratio of the length to height should be 3:2, and that's why the statement 2 is correct and not the first. This Flag Code does not talk about size. पुन्हा हा क्वेश्चन नॉलेज वर जरी वाटत असला तरी हा लॉजिक वर जास्त आहे. या सिरीजचं तेच एक सिग्निफिकन्स आहे की वी आर टॉकिंग अबाउट हाऊ टू सॉल्व द क्वेश्चन्स, इवन इफ यू नो, इवन इफ यू डोंट नो द ऍक्च्युअल नॉलेज. If you just reading this question, reading the first statement, you can find out there is something wrong in this statement, because there can be flags of different sizes, and how can they just make a particular size standard and other sizes not standard? That's why by logic you can eliminate the first statement and you can go for the second, and this should be knowledge based actually. Now what about the question number 13? Okay, the answer was statement 1 is incorrect and statement 2 is correct. What about 13? The consider the following statement is respect to Constitution Day. Okay, the Constitution Day is celebrated on 26th November each year, right? And the constitutional values, to promote the constitutional values of citizens. And yes, and statement 2 is on 26th November Why the 26th November is significant? They are asking about why we celebrate Constitutional Day. On 26th November 1949, the Constituent Assembly of India set up drafting committee under chairmanship of Dr. Babasaheb Ambedkar to prepare draft Constitution of India. Okay, very simple question. From childhood we know that 26th November is celebrated as a Constitution Day because the Constituent Assembly adopted the Constitution. Okay, it was not that Dr. B.R. Ambedkar, the chairmanship of Dr. B.R. Ambedkar and the committee of drafting committee was set up on this date. It is not the correct statement. It was set much earlier than that. But actually, what is the significance of 26th November? Constituent Assembly adopted the Constitution and we enacted. I mean, that Constitution became in effect on the 26th January 1950. Okay, so by this logic, by this knowledge, the statement 2 is directly wrong, absolutely wrong, but statement 1 is correct. So yes, by this logic, we can say which one is the right answer. Then the statement 1 is correct, but statement 2 is incorrect. What about the question number 14? Okay, again, very interesting question. According to Constitution of India, central government has the duty to protect the states from the internal disturbances. This question is sourced from the topic of emergency. And in these emergency topics, we have different articles like Article 352, 356, 360. But beyond that, one important article is there that is called as Article 355. An article under Article 355, central governments has the duty to protect the states from the internal disturbances. It is the prime duty of central governments. Okay. So yes, by this logic, according to Article 355, this statement is correct. What about the second? The Constitution of India exempts the states from providing legal counsel to persons being held for preventive detention. Again, I would like to read the question, the statement again. The Constitution of India exempts the states, okay, from providing legal counsel of person being held for preventive detention. Indian Constitution and the system of judiciary in India is very just. It provides legal aid to any person. Then how can it deny that legal aid to a particular state? By that logic, a state should be given the legal aid by the judiciary. And how can the Constitution exempt the state from having that legal aid from the judiciary? By this logic, it's very simple logic, you can eliminate the second statement. And according to the third, according to the Prevention of Terrorism Act POTA 2002, confession of the accused before the police cannot be used as evidence. You know that there are many provisions in our laws and constitution where the confession of the accused cannot be used as evidence in front of judiciary. Yes, that statement is correct. But it can be used in certain, you can say, extraordinary cases. It can be used in certain extraordinary legislations like POTA, like Terrorism Act. In Terrorism Act, if a particular accused gives statement to the police or he actually confesses his crimes, that can be used as evidence in front of the judiciary. So yes, it can be used. Okay, so confession of the before cannot be, so no, it can be used. Okay, that's why only one is correct in this idea, the question number 14, right? And what about question number 15? The members nominated, again, okay, just one point. Yeah, question is about with respect to election of president. Yes, I told you just few minutes before that idea, the topic of presidential election was very important, and this is second question we are observing from the same paper about the processes of the election of the president. The members nominated to the either house of the parliament or the legislative assemblies of the states are also eligible to be included in the electoral college. The first idea, they're asking about what is the electoral college of president. म्हणजे presidentला कोण कोण निवडून देत. You know that the election of the president is indirect election. What is indirect election? What is the meaning of indirectness? It is the meaning, or it is the answer that the elected members should elect the president. Okay, that is called as indirect elections. But the elected member should be there in electoral college. How can nominated members be included in the electoral college of elections to the president? Because nominated candidates are nominated by the governor or the president. They cannot be elected. They cannot be included in the electoral college. No, that's why this statement is wrong. Higher the number of elective assembly seats, higher the value of votes of each MLA. Again, few years back, they had asked, in I think, if I'm not wrong, they had asked this question about the formula of the presidential elections in 2018. Okay, that was surprising at that time. But by studying PYQs, now you know they are asking about, they have again repeated the question. Okay, higher the number of electoral assemblies, and as you know that the value of particular MLA, value of one MLA is nothing but the population of the particular state upon the number of seats in the legislative assembly, है ना, seats in the assembly. Okay, population divided by seats in the assembly, and by this formula, as the seats in the assembly increases, the value of the MLA will decrease, or as the population will increase, the value of the MLA will increase. Okay, this question was again a tougher question. Higher the number of elective assembly seats, higher the value of vote. Wrong, because seats and the value of MLA are inversely proportional. Okay, wrong. The value of vote of each MLA of Madhya Pradesh is greater than that of the Kerala, right? Before going into the facts, let's discuss this option, this statement logically. As you know, Madhya Pradesh has and Kerala, okay, Kerala, the population of Madhya Pradesh is much more higher than Kerala, right? As the population is higher, the value of what you can say, the MLA will be higher, but the number of seats in Madhya Pradesh are more than Kerala. And that's how, as the seats in Madhya Pradesh are more than Kerala, the value of the MPs of Madhya Pradesh, I'm really sorry, the value of the MLAs in Madhya Pradesh will be less than the Kerala. And just I would like to mention one fact here. I have the numbers with this question. Yes, the value of one MLA in MP is 131. Okay, and the value of Kerala, the MLA of Kerala is 153. Okay, why? Because Kerala has fewer number of seats in assembly, and Madhya Pradesh has more number of seats in assembly or more number of MLAs, and that's why according to this formula the number becomes wrong. And these statements are connected, these two connected, as if you are thorough with this first statement, the idea of first statement, you can correct this statement also. Fourth, the value of vote for each MLA for Pondicherry or Puducherry is higher than the Arunachal Pradesh, because the ratio of the total population of the total number of elective seats of Pondicherry is greater than as compared to Arunachal Pradesh. Okay, the population वर त्यांनी विचारलंय, but factually बघायला गेलं तर the population of Pondicherry and Arunachal are same. Okay, population is same, but despite that the value varies. का व्हॅरी करते आपण त्या फॅक्टर नंबरवर बोलू. पॉंडिचेरीची व्हॅल्यू जी आहे, व्हॅल्यू इज 16 फॉर पॉंडिचेरी. ओके, अँड दॅट फॉर Arunachal Pradesh is just 8. Okay, and why this change is there? Because of the number of seats in their assemblies. So as the number of seats in the assembly vary, the value of that particular MLA will vary in a particular state. So this question was somewhat tougher, but if you are thorough with the second statement, the exact correctness of the statement, you can solve the rest of the two answers. And by this logic, by this knowledge, you can observe कि the only statement 1 is right, because all 1, 2, 3 हे सगळं काही हे करेक्ट होतं, I mean wrong होतं. Okay, so only one statement is right. Which statement is right? Because by the way त्यातलं ते आहे this one. Okay, the third is right. Okay, if I'm not wrong. Yes, exactly. The fourth, I'm really sorry, the fourth is right. आपण इथं परत क्वेश्चन वाचू. The nominated members हे आपल्या इलेक्टोरल कॉलेज मध्ये नाहीत. Exactly. So the first statement is wrong. Okay, this is wrong. Higher the number of assembly seats, more the value. Again, no, because they are inversely proportional. इथे पण त्यांनी फॅक्च्युअली गडबड केली, कारण केरळाची व्हॅल्यू इज मोर दॅन मध्य प्रदेश, अँड द फोर्थ इज राईट. ओके, सो दॅट्स हाऊ our right answer becomes only one statement is right. So on this note, I would like to thank you very much for this session. This session was about the UPSC prelims questions from Indian polity from 2023 year. Okay, thank you very much for this session. We will meet soon with another set of questions from PYQs. And just a footnote for this session, focus on PYQs more than any other test series, because PYQs will serve as the North Pole, the guiding light for preparation. As you know, you should analyze the trend, you should analyze how they are framing the questions, what is their language of the questions, and they are repeating the themes again and again. Thank you very much for this session.